Each side will have 15 minutes, and you may reserve up to 5, just let me know.
Okay, yeah, we'll plan to do the reserve. Go from there. All right, well, good morning. My name is John Johnson. I represent Steve Hochstetler. This is Steve right here sitting at the council table. The issue that I'm asking the court to decide here today is whether a driving violation coupled with bloodshot and glassy eyes is sufficient to establish justification for administering field sobriety tests. That's it. As you know from looking at the transcript and the briefs, Steve was driving on State Route 241 heading north on May 15th, 2015. It was about 10:09 p.m. And a trooper was behind him. Now, the trooper observed some weaving in his lane, but not sufficient to pull him over. And then Steve made a left of center violation. He went across the center line as he went around a curve on State Route 241. Based on that, the trooper initiated a traffic stop. The trooper testified that it took a long time for Steve to pull over. And when Steve did pull over, the trooper approached and engaged Steve in a conversation. During that conversation, the trooper asked Steve why he was on the wrong side of the road. And Steve, before he even had a chance to answer, the trooper offered him an explanation and said, "Did you just cut the corner to save time?" And Steve confirmed that's what he did. The trooper then observed that he had bloodshot and glassy eyes, and he asked Steve about that. Steve said he was tired. Based on those facts, the trooper elected to administer a field sobriety test.
Now, this was at 10 o'clock at night,
10:09, yes,
and he said he was driving
to
to
Canton.
Canton. That was not in the direction of his home.
Right, he was driving from his home to Canton. That's what he testified. That's what the trooper
Did he
testified.
indicate, I don't remember reading in the briefs, indicated where he was going in particular, or why he was driving at 10 o'clock at Canton, if he was tired or whatever?
No.
Obviously, it's a free world, but you're not free country, but I'm just wondering if he offered any explanation.
No, there was no explanation offered or even requested. So the reason that this case is in front of you is because there was no indication that Steve was impaired by alcohol or that he was impaired by any drug abuse. The trooper candidly
You
said,
mean prior to the field sobriety?
right, I'm trying to focus on that. Because the trooper candidly admitted that he did not smell any alcohol on Steve. The trooper asked Steve if he'd been drinking, and Steve said no, honestly. And at that point, based on the red glassy eyes, he pulls him out of the vehicle.
And but he asked him prior to the field sobriety too, when's the last time you smoked marijuana?
That's correct, but that was after he had already got him out of the van. And what I'm focusing on is whether he should have got him out of the van to begin with, because his purpose was, as he testified to, was to administer these field sobriety tests. That was the whole purpose of getting him out of the van to begin with. And what I'm arguing is that he didn't have enough reason, enough articulable facts to do that.
How long have you been tailing him before that?
I don't remember the exact amount of time. It wasn't very long. I mean, the trooper wasn't even following Steve per se. He was on his way to a traffic accident that occurred further north on 241. He got behind Steve and saw what he characterized as weaving in the lane, but not sufficient to pull him over. And then Steve went left of that center line going around a curve. So I don't remember specifically how long it was that he was following him. Now, the cases that we've cited, of course, or at least what I believe to be favorable to us, articulate some factors that can be reviewed by the court to determine whether an officer has this justification for administering field sobriety test. And among those factors is the location of the driving, whether it's near any kind of bars or establishments that serve alcohol. In this case, the answer to that question was it was out in the middle of the country on State Route 241, and there's no bars anywhere around. Another factor the court can consider is whether the person has obvious impairment in his ability to do things like get his wallet out, or provide his license and registration. In this case, the evidence was Steve had no difficulty whatsoever producing his license and registration. Another thing that the officer can rely on are things like slurred speech. There's no evidence of slurred speech at all in this case. Another thing the officer can rely on is an odor of alcohol. In this case, there was no odor of alcohol. Another thing the officer can rely on is whether there's, for example, a smell of marijuana, either on the person's clothing or emanating from the inside of the vehicle. Nothing like that existed in this case. Steve didn't appear to be lethargic. What he had was red and bloodshot and glassy eyes. That's what the trooper testified to at the side of the van. And that, coupled with this left of center violation, prompted the trooper to have him get out of the vehicle and perform field sobriety tests. And again, it's our position that that just isn't enough. If it is enough, then there doesn't seem to be any reason to have a test to determine whether it's appropriate to do field sobriety tests. Because, you make a driving violation and you're nervous and you pull out your license and you fumble, boom, that's enough for field sobriety test, regardless of whether there's any indication of alcohol and any indication of drugs, which in this case there wasn't. So the cases that the state cited to support its position all had an odor of alcohol, every single one of them. They had some kind of driving violation plus an odor of alcohol. In some of the cases described the odor of alcohol as strong or moderate. Those cases, someone who had admissions of drinking. None of those things exist in Steve Hochstetler's case. We're asking the court to look at the totality of the circumstances. That's what we're talking about here. And make an objective determination that in this case, this officer did not have sufficient facts that would justify the administration of field sobriety tests. So that's what we're asking for, and we're asking for a reversal. Thank you.
May it please the court, Mr. Johnson, Nathan Shaker on behalf of the appellee, the state of Ohio. Clearly here we are arguing about what is enough of the totality of the circumstances. And the first discrepancy here is in the way the court and the state viewed just the sheer number of circumstances in those factors enumerated in evidence versus the way the defendant's focusing only on two circumstances. By my count, the court looked at 6 circumstances. The weaving within the lane. Very specifically, the seriousness of the marked lanes violation, the entire departure from the lane.
What do you mean, the whole car was over the
The
lane?
whole van.
Was that during the turn only, or was it when he was driving straight?
It was
until he
going,
got
it
to-
was over, he just cut the corner of the curve, but the van, this was not tires on a lane, it was completely within the other lane of travel. And the court noted that shortly thereafter, another car was oncoming in that same direction. So, it was dangerous driving. There was also the trooper's testimony that Mr. Hochstetler was slow to stop. Again, that can be one of those circumstances. It's not dropping your wallet. It's not those kind of coordination things, but it can be indicative of some kind of intoxication or impairment.
Did the officer testify how long it took him, or what distance he traveled before his son?
I
Or is it
recall,
reflected on the video?
I believe the trial court put at the times, and it was a matter of seconds, and then the trial court quantified it as the vehicle was pulled all the way off the road. But
Well, I know the trial court said in its entry he was able to pull all the way off the road. So I
Yes.
didn't know exactly what that meant, whether that was a factor in his favor or a factor against him. I just wasn't sure.
I believe that's a factor in his favor, but the length of time it took to stop is a factor. The red bloodshot eyes, obviously, that's one of the primary considerations. And then the trial court did go at great length into looking at the inconsistency of the story, as the court has brought up, that this is an individual who lived in Apple Creek, Ohio, said he was tired, but chose at 10:09 at night to drive to Canton. Obviously, you can do that, it's perfectly legal, but that is a factor. In the Evans case cited by the defense in this case, they specifically talk about the difference between driving on Friday night versus driving on a Tuesday morning and the prevalence of impairment at this time.
Was there anything in the record as to why he was going to Canton?
No.
He could have had a perfectly legitimate
He could have had a perfectly
reason to be out despite being tired.
Correct. I mean, he didn't say that it was an emergency or anything else. It's just simply that he said he was tired. And it wasn't that sometimes people say they're tired, I just got off work at the late shift and I'm driving home, and there wasn't that explanation offered. But again, that's kind of addition by subtraction. But this was 10 p.m. at night. So we do have substantial factors, and then we do have the factor of the slight odor of alcohol that came out once he was removed to the patrol car.
Now, how did that happen in regard to? He'd already made the decision to give him the sobriety test before.
And if he would have stopped it at that point in time, I mean, at some point you have to take into consideration the length of the detention, and that's what the problem was getting at. That this was a pretty minimal detention, and fairly often troopers and law enforcement ask people to at least step from a car so they can smell an odor of alcohol. I don't believe there's any case law that has done away with an officer's ability to do that.
But he didn't testify that that's what he was doing. Nor did he testify that he smelled it when he stepped out.
Correct. Once he had them in an enclosed area. Correct. And especially in this age of, I understand that the defense would like a rule where we require something indicating either the use of a drug in terms of marijuana shake on the ground or the odor of alcohol, but
Or the odor of marijuana.
or the odor of marijuana. But we have drug driving laws that have per se levels for cocaine and for drugs that do not have any distinct odor. So in this kind of case, this is a smaller amount of circumstances than we typically would see. But the court looked at everything, and its judgment in that totality was not in error, given the trooper's experience and those 6 factors.
I guess we've seen so many cases, it's very, very difficult for law enforcement when drugs are involved. Obviously, for life, less complicated with alcohol because you usually have the odor and so forth. And a lot of the cases with marijuana, like you said, we either have a shake or we have a smell or odor of marijuana that they've smoked recently. With the other drugs, obviously it gets a little trickier. But I guess I'm just wondering what your response is to the appellant's arguments about that we have this test, that we have to have, some protection here, because otherwise, you just commit a traffic violation, and the officer, when they stop you for the traffic violation, can just say, okay, well, we're going to do a field sobriety test too, and hey, maybe 5 times out of 10 you get lucky.
And one, it is a minimal intrusion, but in this case, we have
If you're not the one doing it, it's a
No,
minimal intrusion.
we have the egregious violation. I mean, this was a dangerous violation. We have the red glassy eyes, which, I mean, these officers are trained, and the officer went into great length in this case about red conjunctiva and the specific manner in which the eyes were a clue. And we have that statement. Even though it is completely legal, we're looking at all those together. We're looking at the night. I mean, it is on the low end of the spectrum, but when all combined together, I think there is significant substance to that officer's suspicion. I mean, I do think it is reasonable and articulable, and I think there's enough there to warrant that intrusion in this case. I don't believe it's just simply, I got a speeding ticket, the cop's gonna put me in the back of the car and make me do the test. There is more here than that. And the telling thing is, when I was looking through both of these cases, that there's just a dearth of law generally about drug driving situations. I think both sides, the cases that were cited, were all pre-2006 drug driving. So I think that is an important consideration in how law enforcement and how this court decides it obviously affects what law enforcement will do going forward, because it is a different world than the pre-2006, pre-per se level world. Thank you.
You have 5 minutes.
The state, and in fact, the trial judge focused on the egregious nature of the violation, as what Mr. Shaker just said. And the interesting thing about that characterization is the traffic citation itself. It's part of the record. And if you look at that traffic citation, about a third of the way up, there are a number of boxes that can be checked. One of which is crash. Another of which is almost crash. Neither of those boxes was checked in this case. We're not disputing Steve Wood left of center. We're not even disputing the trooper when he says he went completely left of center. He was going around the curve, cutting the curve. You do that sometimes. But to suggest that violation alone is something that suggests impairment is
Well, he's saying it's not that alone, that's the whole point. And I think what he's asking us to do is I know that there's case law about the test and so forth, but I think he's asking this court to take a look at the new environment we're in with driving under the influence of drugs instead of alcohol. Because it is a difficult case for everyone concerned, for law enforcement as well as for the drivers and for the court. Everyone's rights need to be protected here, obviously, the defendant first and foremost. But I guess the whole thing is, what is going to be that test in particular? And you're saying, well, it's not going to be enough just to have a traffic violation, and maybe even an egregious, if you want to call this egregious traffic violation. But I think the prosecution is saying, but that's not what all we have. We have the bloodshot eyes. We have somebody that's slow to pull over. That's the testimony, whether it's credible or not. The trial court found it credible, and that's what we have to go by, what the trial court found, if there's competent credible evidence to back that up. So I guess the point is, they're saying there are these other, maybe not a lot, but there's other factors there. So I don't know that you can say it's just the traffic violation. So what's your response to that?
well, the reason for the stop was the left of center. There's no question about that. The other things that the trooper observed with the driver, let's assume that all of that is completely accurate. The trial judge did, right? Weaving in the lane, left of center, and then it took him a while to pull over. How does that remotely, even when coupled with bloodshot eyes at 10 o'clock at night, how does that give the officer any basis to believe that the person is under the influence of drugs of any kind? Because the officer didn't testify that he observed any, sweating. Sometimes a cocaine user, they're going to sweat, or methamphetamine, they're going to be shaky. A heroin user, if they're under the influence of heroin, oftentimes they're going to be nodding off and very lethargic, very tired. None of those factors, none of those things were ever observed by the trooper. If they were, then I'd say we may have a problem. Okay? In the same way, if the trooper had smelled marijuana, boom, we're not even talking about it now. We wouldn't even be here for that. But we don't have those facts. So, the question is, well, what do you do? Like you said, that's going to be your decision here, because I don't know what to do. All I know is that you have to have something that suggests that the person is impaired by an illegal substance or a legal substance, alcohol. And in this case, we don't. We just don't have it. And because of that, we're asking the court to reverse the trial court. Now, one last thing, because I know I'm running out of time, but the prosecutor mentioned the red conjunctiva. I think that's what the trooper testified to. If you look at the trial transcript, the trooper testified that his only observation when he was talking to Steve at the van was bloodshot and glassy eyes. The conjunctiva stuff, that came in later, after, obviously, Steve was out of the car and probably was doing the field sobriety test, although that was never explored. So the factors that the trooper relied on were the driving and the bloodshot glassy eyes. That was his testimony. So the conjunctiva stuff, the odor of alcohol, all that happened after the trooper got him out. What we're focusing on is what justification did he have to pull Steve out to perform these tests. Okay? Thank you very much.
Thank you both gentlemen for your presentation to the court. The court will take the matter under advisement and issue a written